Okay, I welcome to all participants in this webinar. I am Jean-Pierre Brun. I am working at the World Bank and at the Stolen Asset Recovery Initiative. I am based in Washington, D.C. And I am very pleased and honored to moderate a panel on a very, very interesting, fascinating, and key topic for the world economy and the world governance, which is cross-border insolvency powers in sovereign asset recovery and sanctions. Our distinguished cross-border panel comprises of legal experts, cross-border asset tracers, certified fraud examiners, and litigation funders. And all these fantastic experts will focus on key themes that are key to asset recovery issues. Offshore multi-jurisdictional litigation and asset recovery, asset tracing, discovery and disclosure, financing risks in asset recovery actions, and utilizing cross-border instruments and legal models to establish control over sovereign-owned assets and assets subject to sanction freezes. So in this session, we will use a range of recent cases to bring the subject to life. And I am very, very happy with it. And the panel is going to have as main speakers Angela Barkhouse. Angela is a managing director on cross-border asset recovery at Quantuma in the Caribbean. She is the head of the asset recovery group. Angela is an expert in financial investigations, offshore asset tracing and recovery, data analysis, and intelligence. She is recognized as a global elite thought leader in investigations and asset recovery. And she has been involved in the asset investigation and recovery of stolen state funds in Africa, in the Middle East, North Africa, Caribbean, Europe, South Asia, and Southeast Asia for over 12 years. And by the way, one question to Angela will be in which region she has not been involved actually on asset recovery. Okay, second speaker, Yasser Dajani. I hope the pronunciation is okay. Okay, Yasser, you are managing director and head of the Middle East practice at Quantuma. You are an experienced advisor with a lot of expertise across forensic accounting and investigations and cross-border assignments. And you are also the head of Quantuma Middle East practice and responsible for leading business across the region from the Dubai office, since Angela was in the Caymans office. Then we have Stephen Baker, senior partner at Baker and Partners. Stephen is a partner and has been instructed repeatedly in major litigious matters, including many of Jersey's leading contentious trust matters. Stephen, you are frequently working to advise on the strategic approach that needs to be adopted in cross-border litigation. You you also were the chairman of the International Bar Association Asset Recovery Subcommittee between 2018 and 2020. And in 2019, you were called to the BVI bar. And I add also that at the STAR initiative, the World Bank UNODC Stolen Asset Recovery Initiative, we were very happy to partner with you to work on some of our publications, and specifically our publication Going for Broke, which studies how to use insolvency legislation and tools and practices to recover proceeds of corruption. It is one of our recent publications, and really we are very thankful for the assistance that you provided us. Then we have James Little. James, you are a principal at Drumcliff Partners, which is a litigation finance fund dedicated exclusively to financing and managing the recovery of assets for the victims of global fraud and corruption. Prior to founding Drumcliff in 2010, you have spent several years in the private equity and national security industry. Thank you for being with us. And we have Paul Kennedy, partner at Campbell's. You are working, Paul, within the litigation, insolvency, and restructuring group based in the Cayman Islands office. And you have specific expertise in complex cross-border disputes relating to funds and other offshore structures, asset recovery claims, and fraud investigations, and breach of duty claims in relation to the managers, auditors, administrators, and custodians of investment vehicles. So thank you very much for honoring me with the task of moderating this panel. And I am going to turn to Angela Barkhouse for the first question. And maybe, Angela, you can explain to us simply what has been your experience in investigating and recovering assets and what you have learned from the cases you have been involved in. Thank you. Angela, you have the floor.
Thank you very much, Jean-Pierre. Thank you, and welcome to everybody who's on the webinar today. I think one of the first things that's probably worth mentioning is that I've learned that no asset recovery assignment is ever the same as another. So you definitely need to have your wits about you and to have a very broad set of skill sets. And that really means understanding a lot across the criminal kind of aspects of things, regulatory, dealing with regulators, etc. as well. What happens between governments in bilateral assistance requests, but also having a really good understanding of investigations, contractual disputes, dispute resolutions, and of course, what this subject is about is insolvency. And so for me, really, it's there's also the political risks that are involved with, dealing with corruption cases as well. And I've learned, sometimes to my detriment, that you can't avoid these political risks. So, for example, there has been regime change when I've been instructed on a case. I can give an example of when I was instructed and had been working for 18 months on a particular case, and it was a civil action case. And we took it to a different jurisdiction because we were unable to do it within its own jurisdiction due to judicial non-independence. And unfortunately, there was a coup, and then 24 hours later, I was disinstructed. So you have to kind of protect against those kind of political risks that come with it. As I said, judicial independence can sometimes be an issue as well. I've been involved in yet another case where we were looking at obtaining, and I was supporting the local police and the law enforcement agencies in investigating some serious levels of accusations of corruption And we asked to get a search and seizure order, and we went to the judge and we got the search and seizure order. But within that search and seizure order was a provision to give the defendant 24 hours notice of our arrival. So as you can imagine, with him knowing that we were coming, there was very little left to find. So really it's about the political will as well of how we're going to pursue that. But one of the things I have learned to my advantage is that insolvency as a tool can be incredibly effective in mitigating those risks. And that's something that we'll talk about obviously during this webinar.
But specifically, can you describe a little bit more more in detail this insolvency tools that we can use in asset recovery cases? And by the way, I think you also contributed a little bit to our publication at the STAR initiative on going for broke. So I should have mentioned it, and apologies for that, for not mentioning it first. But now, if you can explain to us more in details, that would be great. Thank you.
Not at all, not at all. I mean, thank you for that. I mean, you know, the great thing about having a liquidator appointed in a corruption case is the ability, where there are entities involved, is to effectively turn the corporate structure on its head. So this corporate structure, which was set up in order to provide for fraudulent transfers, perhaps in secrecy jurisdictions, to hide the UBOs, etc. The ability to put a liquidator into those entities can effectively be very, very useful, not only in obtaining information from those secrecy jurisdictions, but also from third parties as well. So the liquidator, what the liquidator does is he or she stands in the shoes of the company, and that often means that that liquidator has a contractual right to receive certain information from third parties. For me recently, for example, we've been able to obtain information on bank accounts and banking transactions, which if we had gone down the road of doing a normal civil remedy disclosure request, we would have had to have made that request against many entities, against many banks. But as we had that, effectively, what we are able to do is also, as part of that, obtaining information and evidence gathering, is seek assistance from foreign courts. So the liquidator has a protection of the domestic court in which they are appointed, and that's useful for a number of reasons, including preserving claims and protecting the liquidator from interference. But when you're looking to obtain information and gathering evidence, the ability to then seek information from another jurisdiction and ask that court to assist you in either, you know, making an examination of someone or insisting that they turn over information can be extremely expedient in doing so. And again, an example, very much so, in one case, we were appointed over a number of entities, and so these entities formed a corporate structure which, you know, transferred funds to each other, and we wanted to be able to obtain the information from banking records. We knew that local law enforcement agencies and foreign law enforcement agencies had been involved in investigating this particular corruption example. And we found that within a very, very short amount of time, within 9 months, we were able to identify unknown individuals that owned entities or had access or signatory authorities over bank accounts. We were able to obtain information on unknown entities that had received funds that these law enforcement agencies were not aware of. And that gave us routes to recovery that were not previously open to the law enforcement agencies themselves. And so we feel that that was a really good example of how the liquidator's powers in obtaining information and evidence using or underneath court sanction was extremely expedient, but also time efficient as well.
Thank you very much, Angela. That's very fascinating, and I'm sure that we are going to have a little bit more stories later in this session from all the panelists, because there is a huge wealth of experience in this panel. But I'm going to turn to Yasser at this stage about asset tracing. Yasser, you have been involved in a lot of missions about asset tracing, where you were asked to find stolen assets, proceeds of corruption, and not necessarily, we discussed that before, not necessarily only in the insolvency context. So can you explain to us what you did? Thank you.
Thanks, Jean-Pierre, and great to be here, and thank you all for joining the webinar. As Jean-Pierre mentioned, I'm a managing director with Quantuma based here in Dubai. But before I respond to your question, Jean-Pierre, let me explain very quickly that asset tracing investigations have many different objectives. They can be part of a fraud investigations. They can support freezing orders. They can be used to confirm disclosures by individuals under oath and depositions, or as part of guarantees to creditors. They can also be used to demonstrate dissipation of assets and destruction of value. But today, I'm going to be talking about asset tracing in the context of making recoveries in public corruption cases. This includes fraud, gross embezzlement, kickbacks, abuse of public office, and so on. One thing I want to point out is that, just to clarify, is that I do make a distinction between internal asset tracing and external asset tracing. I will not dwell much on it, but external asset tracing, which is what I'm going to be talking about, is intelligence-led and relies on field investigations, which plays an important role to facilitate future recoveries. Of course, my dream would be to have external and internal as a combo, doing them simultaneously, because that's really the most effective way to identify and recover assets. In terms of the approach to asset tracing, in sovereign debt situations, from experience, these investigations are complex and time-consuming. And as Angela mentioned, no asset tracing investigation is identical to the one before or to the one after. And there is no cookie cutter approach to asset tracing investigations. That is why when we are tasked with an external asset tracing investigation, we always take a step back to determine what is the scope of work, what is the methodology to help us define a very robust structure to move forward. It is also important to prioritize the objectives and a list of targets. And this is particularly the case in investigations where dissipation of assets has occurred. Now, every asset investigation is different, as I mentioned, but broadly speaking, they typically commence with a review of public domain information, just to establish a baseline initial indication as to quantify and qualify the volume and nature of information out there on a target. We are living in an age where electronic information, the internet is out there, and we utilize that to gather as much information as possible. We're not yet looking for assets, and that's an important distinction. We are looking at behaviors of targets that could lead us to potential location of assets. Technology is critical in these investigations, particularly when it comes to deep web and social media and social communication analytics, to give us certain ideas and leads in terms of where we need to focus our asset tracing investigation, which they're all cross-border, they're all global, especially when you don't know where to look. Public records, though, I have to admit, in many offshore financial centers, the public record is not public or much of a record, but the data does provide helpful leads. Surveillance and site visits, especially where they are legally permitted, which is not everywhere in the world, especially in the Middle East, but where they are permitted, they do provide actionable intelligence. Now, in terms of the asset classes, what are we looking for when we go look for assets? We usually put them in three buckets. They're the corporate assets, and that includes shareholdings, that's joint ventures, partnerships, etc. Financial assets, funds, receivables, and of course, bank accounts, which tends to be one of the most important things. And finally, tangible assets, land, real estate, equipment, inventory, vessels, wine collection, whatever the case may be. Now, let me just say this. Asset tracing will generally result in a range of assets linked to targets. However, and this is a very important point, the evidence linking the assets to targets will be of varying degrees of strength. If my colleagues can put up the slide just to explain what I mean by that. So this diagram shows where asset tracing have identified 20% of a target's assets by way of documentary evidence, which is the box on the upper left. And that's great. Other assets, however, will be supported by intelligence or at best circumstantial evidence that would require further investigations. This could lead to more evidence that might increase the probability of assets by, let's say, another 20%, resulting to 40% of a target's assets being identified. These numbers are example. They're examples. They're not specific, right? But the point here is that external, in isolation, will not result in 100% of assets being identified. And there are, of course, practical and legal considerations, which I will not get into here. But one key area is that the assets need to be sufficiently linked to the proceeds of financial crimes, which is another area that we will probably cover during the webinar. There's also the issue of MLAs and RLAs. And finally, of course, establishing the nexus to a jurisdiction where the assets are located to allow you and to facilitate the process of seizure and disposal and recovery. Now, time frame and cost are always difficult to predict. Again, going back to the issue that not every asset tracing investigation is the same, but there are a range of factors that will have an impact on the probability of finding assets, on the time and the cost. It's the complexity of the fraud that has been committed. The more time between the offenses and the investigation itself to find assets, the harder the investigation will become and the more difficult to identify assets. The complexity of the corporate structures that are involved in holding assets. And Angela, my colleague, is an expert in identifying assets in offshore jurisdictions, and she'll probably talk more about that. Whether there's been concealment to proxies, third parties, or whether the assets have been sold and the proceeds have ended up in bank accounts that we're not aware of. Financial information is also very difficult. Like I said earlier, whether the legality of surveillance and admissibility of evidence is permitted depending on the court of law that you are dealing with. All of these factors increase the time, the complexity, the cost of tracing and recovering assets. In my experience, wealthier and high-profile targets are always more elusive. They spend more time and effort to shield and conceal their assets. We typically continue until either assets are identified that are commensurate with the value of loss, or until we feel that the investigation is no longer financially or commercially viable.
Thank you very much, Yasser. That's extremely clear and interesting, except one thing that is not 100% clear for me. When you are speaking about surveillance, I don't know if Quantuma has specific tools to organize surveillance of targets, or if you go to courts or to prosecutors actually to ask for government activity on this side, because it's a little bit delicate. And the second quick question is that do you use insolvency in the Middle East as well? Do you, I mean, now that the insolvency regimes have been more established in the region, is it doable to use these insolvency regimes for asset tracing but maybe quickly, because I am afraid we may
Running out of
run
time.
late. Yeah.
Well, I'll answer your first question. Look, I mean, when it comes to investigations and business intelligence, we rely on a network of contacts and sources out there. And where surveillance, again, is permitted, we utilize contacts and sources who are professionals in this particular activity. So we don't necessarily go out and do it ourselves, but we do rely on third parties where we have a contractual relationship with. In terms of the insolvency regime in the Middle East, and I'll be very, very brief because I can talk about this for hours and we don't have that much time. There have been a lot of interesting developments across the region in the GCC, in Saudi Arabia, Kuwait, the UAE in particular. But let's not forget that the bankruptcy, which is what it is called in certain jurisdictions and zone, it's also called insolvency in other zones. They're about 5 to 7 years old, or young, I should say. So there's still a lot to learn in terms of the insolvency environment. In the UAE, where I am based, should I pause here? Sorry. In the UAE, there are at least 4 different insolvency regimes. You've got the DIFC, you've got the Abu Dhabi Global Markets, you've got the onshore insolvency regime, you've got the central bank relating to financial institutions, you've got the regulator of public companies. So there are a lot of different laws to contend with. The DIFC and the Abu Dhabi Global Markets are based on a common law system, which is exactly identical to the UK. In fact, their insolvency laws here in the DIFC and Abu Dhabi Global Markets are almost identical to the UK insolvency law, which obviously provides companies, creditors, investors, shareholders, the confidence. Onshore is where the problem we have, which is really where the majority of businesses are. But things are changing, and there's been a recent development in 2020, 21, and 22 that is changing the insolvency regime environment in the UAE. Historically, till this day, when there is an application for insolvency, a court appoints the insolvency practitioner who is not necessarily an insolvency practitioner. And that has created a lot of issues and problems for creditors in particular. The new law allows for insolvency practitioners to submit an application to be appointed. And that has really, it's too early to tell in terms of what's going to happen next. But certainly the environment is changing whereby an insolvency practitioner can appoint investigators. The fees come out of the company that has filed for an insolvency, and so on and so forth. So the landscape is changing. Onshore, offshore, I would say is quite robust, but onshore, there's still a lot of complexities that need to be worked out.
Okay, thank you very much, Yasser. That was very extremely interesting. Stephen Baker, now the question that I have is, we all know that asset recovery is politically sensitive. So how do you do to manage the political risk of I mean the political risk of collapsing the case based on political pressures or absence of political will also sometimes. So thank you.
Well, Jean-Pierre, thank you for such an easy question for me to answer, which I'll do in five minutes with a very full and comprehensive explanation. But I think picking up on what Angela said a little while ago, a coup can be a little bit of a problem, and if you don't see it coming, it can be an even bigger problem. But of course, the answer to your question is completely fact specific, and I'm going to give a slight spoiler alert by saying that Paul's going to tell you how you might do something to protect a claim, even if there's a coup or a risk of a coup. I'm going to leave that. I'm going to leave that to him, much as it's tempting to give that explanation. I'm going to give you some examples from cases I've been involved in. Political will is absolutely key, and in every case that I've been involved in involving corruption, I think it's true to say that where the political will has remained, we have recovered assets, and where it's gone, we haven't. We haven't. So political will is absolutely essential. One way that we've looked to deal with that is not to take the corrupt politician on head on. So if somebody goes out of power, it doesn't mean that they actually have no influence and no power. Behind the scenes, they remain very, very powerful, influential people. That's the nature, or part of the nature of corruption. It's a feature of corruption. So what we've tried to do is to take action against facilitators and what would be called in other circumstances aiders and abettors. So if you can sue an offshore company for dishonest assistance, knowing receipt, or unjust enrichment and the like, that can sometimes take the heat out of things at home, in the home jurisdiction. So the corrupt politician can lie to the press, lie to his people that he has nothing offshore, nobody's ever issued any proceedings against me offshore, when of course the truth is that proceedings have been issued against the offshore companies that he's been using to launder money. And the central allegation in the case is that the controlling mind, the will of the company, is the corrupt politician. So Paul will come up with a really sexy answer to the question. Mine is more mundane. Pick your targets really carefully and think that through.
Thank you very much. And since I remember we have discussed many cases that you have handled in asset recovery. Can you tell us what is your experience for the evidentiary issues or requirements that you are facing in court?
Yeah, sure. And I'm going to focus, for the purpose of this answer, on evidence at trial. So what sort of issues come up at trial? And of course, the first thing you've got to face is that your opponent is going to do absolutely everything to prevent the case from getting to trial at all. So you're faced with dealing with every trick in the book, in the lawyer's book, aimed at trying to get the trial off the tracks before it's even started. And I've had cases where, for instance, on the first day of trial, the defendant, the corrupt politician, turns up with an expert's report saying that the whole contract's now being reviewed, and in fact there's an honest explanation for the whole thing. There was no money extracted from whatever contract it was. Now, of course, you then need a strong judge to say, I'm sorry, that's 5 years too late. You haven't pleaded any of this in your pleadings, and you're trying to hijack the trial. So you get that sort of trick. In one trial that I did, all of my witnesses refused to attend. Or that's not literally true, but many of the witnesses refused to attend. Why did they refuse to attend? Well, because they were all really serious criminals. So they made statements which explained how the fraud worked, how they kept records, how money was paid to the corrupt mayor and the like. Well, when push came to shove, they didn't really feel like giving evidence. One of them asked for $250,000 in order to turn up and give evidence, and we politely declined that kind offer of his to pay him, to turn up and give evidence, and decided that we didn't want to lose our licenses to practice law. So they wanted money and they refused to come. So I suppose that's fairly obvious that was going to happen. How did we deal with it? Well, it was a civil trial. And so we were dealing with the balance of probabilities. We were dealing with easier evidential requirements than a criminal trial. So we just read all the statements anyway, under various hearsay provisions. And then we'd taken great care to put the documents in the right order, to have chronologies, and to be able to say to the court, actually, the case is overwhelming, even without this bunch of criminals who we were only calling because we felt we should. And in the particular trial that I have in mind, the court concluded that the case was proved beyond reasonable doubt, even without the criminals failing to turn up. So bribery and corruption is going to attract bribery and corruption, isn't it? So don't be surprised if your witnesses ask for a bag of loot round the back while the judge isn't looking.
Thank you, Stephen. And I am going to go to Jim now. Jim, you are a litigation funder. So you have a specific point of view on all these cases, and can you tell us how you consider the different risks of litigation funding, and specifically in asset recovery cases, in sovereign asset recovery cases? Yeah,
sure. And thanks for having me, Jean-Pierre. So, well, I mean, after some of the other panelists, it's pretty clear that there are a lot of risks that you have to consider, especially when you're funding asset recovery for sovereigns. We've had several sovereign clients in the past, and as the other panelists have said, there's a lot of political exigencies that come into play when you're funding these matters. It's one thing to kind of lose a client and not have any more work, but it's another thing to lose a client and lose millions of dollars that you've already put towards actually trying to recover value for them. So there are a lot of factors that go into the decisions that we have to make when we decide whether we're going to fund a sovereign or not. To take a step back, I think one of the most important questions that people might ask is, like, why would you even fund a sovereign? Sovereigns literally, in most circumstances can print their own money. So it's not like they actually need the funding. But in our experience, we found that funding plays a key role in actually helping recover value for sovereigns for a few reasons. So first, there's, as the other panelists have mentioned, there's the idea of sort of political machinations at work in the originating jurisdictions, right? So as Steve said, opposition parties are still in the country and still, in fact, in parliamentary systems, they're still in parliament, right? In the minority party, when you're actually trying to recover value from, maybe some of the same people who stole them who are still in government. So funding is a mechanism whereby governments can actually sort of disintermediate the efforts that they have to fund and to recover this value, right? Without having to get budget from, a lot of budgets in these countries are public record. And if people find out that there's a budget in the Ministry of Justice to be able to recover stolen assets from a prior administration, they're not going to be too happy about it. So for them, it's a mechanism to be able to kind of work in secrecy. But also, the most important part is that they can, they don't have to use the system of government and their own bureaucracy to be able to provide the funding. So I think everyone on this call has been involved in matters before where they have paying sovereign clients, but just because they have to call up the Ministry of Finance, each branch of government has their own priorities, and their bureaucracies are kind of slow by design. And when people can move money around the world with a touch of a button, you have to be able to work with a lot of secrecy, like Yasser was saying, and also with a lot of alacrity. If you have the government involved, and you're waiting for your bills to be paid just so that you can actually do the work that you're tasked to perform, it slows things down. So in that respect, we've had some success with sovereigns, mostly because the amount of money that they're actually trying to recover are usually pretty large sums. Unfortunately, corruption is alive and well in the world. But more importantly, we like to use offshore regimes to recover value because we can rely on those systems of law. That's that flight to quality phenomenon that we talk about, where usually when corrupt politicians steal money, they put it in offshore jurisdictions where there's a strong banking system and a strong rule of law. We try to avoid any kind of domestic litigation other than hopefully getting a criminal judgment against the people who committed the crimes, or some sort of domestic judgment that we can transport to these offshore regimes, so we can get things like discovery and hopefully asset freezes and actually recover value offshore. That's a matter of the insolvency process, which we can talk about. But when people ask me why are you funding a client in this developing country where there's a lot of fraud and corruption that's endemic in the country, well, it's mostly because the work that we're trying to do is actually outside of that originating jurisdiction, in offshore jurisdictions. So we can kind of trust the techniques that everybody on this call has developed to be able to recover value for our clients without having to worry about the interference that Steve talked about when you're trying to recover value that's actually domestic, or go after people who still have a lot of influence in government. They might have appointed half the people who have to do the work to help support your efforts before they were taken out of power. So we just try to avoid working in the home jurisdiction, other than having a good relationship with the attorney general, or as someone at a high enough level of government that we've got a commitment from the government to be able to recover the value. And that's very important because in some circumstances, like mutual legal assistance, we actually need somebody who can bind the government to sign affidavits or actually sign those requests. So we have to make sure that either a solicitor general or an attorney general or a head of a ministry of justice who can actually represent the government is our client, because we're going to need we don't need their money, and we don't need their expertise. And in fact, a lot of times jurisdictions are too busy with the process of governing their countries to worry about having to recover value offshore. But we need them to literally sign documents and attest to things so that we can do the work for them.
Oh, and by the way, listening to you, there is one question that comes to me based on my experience and discussions that arise in certain cases. How do you see, as a litigation funder, how do you see the systems of success fees?
Yeah, well, our goal is to provide restitution for the victims of fraud and corruption all over the world, right? And it's just kind of a fact of life that lawyers and accountants and insolvency practitioners, they cost money, and sometimes people don't have the ability. They're either impecunious if all the money's been stolen from them, or they just don't. They have other priorities, frankly. And so our funding is all non-recourse, right? So if we don't do our jobs well, we lose all of our money. And so I think the value that we provide, especially to sovereigns, far outweighs the cost of what they're foregoing for some kind of success fee that we have. We like to use the adage that we try to do well by doing good. And so we structure all of our arrangements so that the client will always make more money than we do if we're successful. And I think after they've realized that, but for all the experience of the people on this call, and then maybe with some funding supported by us, they probably wouldn't have the ability or the expertise to be able to recover any value, but for the funding and all of the hard work from all the people who we have here today. So I think in the end, they think it's a pretty good proposition. Okay.
Thank you very much. Any other reflection on litigation funding and how to manage risks to maximize effectiveness?
Yeah, it's complicated. One of the ways that we can actually, if we're a little worried about things like political will, one of a great mechanism that we can use to offshore to sort of let the client get on with the business of governing while we try to do the work of recovering value for them are actually offshore insolvency regimes. And I think Angela's probably touched on that before. So if we can get some sort of either some evidence or some affidavits or even a money judgment, something that we can transport out of the originating jurisdiction to places where people hide value, then we can actually use. Typically, they hold that value through offshore structures. Nobody's going to steal money and put it in a bank account in their own name offshore. It's just not really that's not how fraud works, unfortunately. But by using the insolvency process in international jurisdictions, we can actually have either receivers or liquidators appointed to the companies where we have a money judgment on behalf of the sovereign against the person who stole the money. And then our client actually becomes the office holder, the person who is responsible for gathering up the assets for that company. And usually those are seasoned professionals when it comes to this kind of work. We've got some of them on this call, in fact. And we can actually, we can communicate with them, and they kind of understand the risks and the ability to act quickly and how to work efficiently to recover value without us having to go back to the client every time we have we need an affidavit to be signed, because they are, in any government, there are busy people at the highest levels of government, and we just need the ability to work quickly. And so actually insolvency, not only is it a great tool to be able to transport money judgments throughout the world, and it's a lot more efficient than things like letters rogatory or using the claimants themselves to try to go after these assets, but also it's more efficient, it's more cost effective, and thanks to UNCITRAL, I guess, the UN model law, it's recognized in a lot of jurisdictions. So it's probably the most efficient way for us to be able to recover value.
Okay. Thank you very much. I invite our colleagues to I mean, if they have questions, to not to hesitate to ask questions in the Q&A. And we will be able to discuss questions at the end of the session as much as possible. I'm turning to Paul. Paul, you have been dealing with sanctions law a lot, I understood, and you probably have seen the use of insolvency procedures in a lot of politically unstable situations. So what is your experience on that?
Hi, Jean-Pierre. Thank you very much. So, there's sort of one example that touches a lot of these bases, which is the Libyan Investment Authority, which is a case I've been involved in for a number of years. I don't know if it's a sexy example as Stephen described it. I think that probably depends what you're into, but the Libyan Investment Authority was the sovereign wealth fund of Libya, which was set up in around 2006, 2007 by the Gaddafi regime. And post the overthrow of Gaddafi, a new government came in 2011, 2012, and started to look at a lot of the Gaddafi era deals. And a lot of them relating to the Libyan Investment Authority didn't pass the smell test. So you had a new government coming in, starting litigation predominantly in London against various financial institutions. So that was sort of the period from 2012, 2014. And what happened in 2014 was the government split, the country split, and there was a civil war in Libya. And the issue then that the various solicitors in London had was that they didn't have, they didn't know with any certainty who they could take instructions from. There was issues to do with funding and so on. So in that case, it was actually the lawyers who applied for receivership over the Libyan Investment Authority's claims in the UK and over their assets in the UK. So that I think is an interesting example of using an insolvency type procedure in order to pursue sovereign asset recovery. There was a sanctions overlay there, but it wasn't particularly relevant to the bringing in of the receivership. And it was successful because it allowed those claims to be pursued, and some of them quite successfully over a period of years. And in that period when that litigation was ongoing, there were various further changes. So there were sort of shifts in the various factions on the ground. There were other claimants, other parties who came forward claiming to be the chair of the LIA. And by the time 2019, there was an application to discharge the receivership. There were 4 separate individuals all claiming to be the chairman of the LIA. So you could imagine if the receivership hadn't been in place in that period, the kinds of issues that would have thrown up for the litigation that was ongoing in London and elsewhere. So I put that forward as an example of successful use of insolvency procedures. There was an application in that period for receivership over 3 Cayman subsidiaries of the LIA, so 3 wholly owned funds. And that was actually rejected by the Grand Court in Cayman on the basis that there was no split at the level of the fund. So you didn't have different parties each claiming to be the board of the fund. You had a single board which had been appointed by the pre-split Libyan Investment Authority. So the court said no to that, and I think that's probably an example of the limits of some of these use of some of these procedures in sovereign cases, and the courts will look quite critically at those applications and decide whether it's really necessary in all the circumstances to have an office holder appointed. So it's not necessarily a panacea or one size fits all solution. But I think the LIA example is a good one.
Yeah, that sounds a very good example. Since I am said that we are running a little bit out of time actually, but and I want to ask a question that is a little bit burning actually before we turn to questions and conclusions. Is that, I mean, obviously we have seen many sanctions decided by many jurisdictions in the recent weeks and months. We all know the events that are ongoing. And in this context, Paul or Angela or other panelists, how would you say, what would you say about the insolvency proceedings? Can they be useful in the context of all these sanction systems that have kind of mushroomed recently?
I'll touch on that very briefly and hand over to you, Angela. I mean, the issue that you face with using insolvency procedures where sanctions are in place is that the same sanctions apply to an office holder as they do to the entity or the individual affected. So you still have the situation where licenses need to be applied for, or you need to look at whether there are exceptions. So if you have a liquidator, for example, being appointed, their job is to go in and gather in the assets and distribute them out. And that by itself will be dealing with sanctioned or frozen assets without a license. So I do think there potentially is going to be a role going forward. I mean, one of the things we're conjuring with in Cayman at the moment is sanctions affecting funds, so collective investment schemes, hedge funds, where you have the 50% rule. For those who aren't familiar, an entity that has over 50% ownership of designated person, the entire entity is frozen. So where we've seen that applied in Cayman in the hedge fund context is where you might have 55% ownership, for example, by a designated person of a fund, but the 45% might be, entirely unrelated to the designated person, entirely unrelated to Russia, just ordinary investors, but their assets are actually frozen by the sanctions regime. And that's something that's given rise to a lot of issues, because if the entire fund is frozen, you can't pay directors, you can't redeem, you can't pay your auditors or any of the service providers, so that it just grinds everything to a halt. And there's sort of a policy discussion around that as to what's the best way to deal with that, and should it be that the designated person gets redeemed out, in which case you have an issue, because where do they go? Those assets are still frozen. Do you liquidate securities? Do you pay them? I mean, ideally to a frozen account, but anybody who's experienced dealing with sanctions know that banks aren't really willing to take on sanctioned assets. So, you're not going to get, I mean, my understanding is there's around 8 billion of assets affected in this way in the Cayman Islands alone. So you're not going to get banks to take on that volume of frozen assets. It's going to affect their operations. And then the flip side of that is if you redeem out the non-designated persons and leave the designated person, so that the frozen sanctioned investments in there, you're not going to be able to manage that going forward. You're not going to be able to run that fund in the way that it was set up to run. And I think in those scenarios, I think we're probably a while off it yet, but I could see receivers and other office holders being appointed in those kinds of scenarios with the necessary licenses to effectively try to wind down those situations.
Yeah, I agree with that. One of the things that, I mean, it's been a topic of conversation that has been obviously rife between industry peers around, the sanctions and how that can be best managed. And obviously, sanctions are created for a specific reason, but the purpose is not to diminish assets, particularly if, you have operating assets with subsidiaries and employees, etc. There must be a way of protecting those assets because ultimately they affect the economy. So, one thing to come out of all of this, probably the webinar entirely, is that the I word, insolvency, is not a word to be feared. It's an education piece really to some of our clients to say that, yes, okay, you're going to use receivers or liquidators, but it's for the purpose of trying to achieve the best value that you can out of the situation, rather than, putting it into an insolvency situation and winding it down, which is a very different kind of scenario.
Thank you very much. I'm very conscious of the time, and I see that we have a question from a participant. And the question is basically, so when you are talking about insolvency tools, so basically, are you talking about receiverships or other processes under the jurisdiction of the state where the fraud occurred? Or are you talking about insolvency proceedings in the offshore jurisdictions against entities that are the recipients of the funds on the basis that they cannot repay them? So that's one question. And the second one, by the same person, and specifically for GEMS, what structures do you prefer to give you protection against changes in the party that is in power in a country?
Well, I think one of the things that I think it actually, the question as to what type of insolvency proceedings, they actually refer to both. So Steve, for example, and I'm going to turn to Steve right now, he's currently dealing with a situation where it's a proceeds of crime insolvency proceeding, where I am often on the corporate side, where we are going against directors or UBOs or entities themselves on a insolvency proceedings against entities. But Steve, do you want to refer to your particular matter at the moment?
Yes, I can. As to the question, obviously, the type of insolvency proceeding that's used and would be referred to depends entirely upon the facts. I don't think we've referred at all to criminal receiverships today, though sometimes criminal receiverships will be very important, and that sets the context of your question. Yeah, this, not me personally, my firm is instructed for the Viscount of Jersey in relation to the Abramovich freeze, which has been all over the press. And obviously I can only say that which is public, and actually I know very little about the detail of the thing anyway. But that freeze followed searches of business premises connected to Abramovich, and I'll give you my source. That's the local newspaper, just so if anybody want to check. And there were searches of those premises, and then a saisie, what's called a saisie judiciaire, was obtained. And from that, you can.
Good accent.
That's a well, Jean-Pierre, you'll know what a saisie judiciaire is. I don't.
Yeah. No, I was congratulating you for the accent. Yeah.
Thank you, thank you. We spoke a lot of French in the northeast of England where I grew up. But the fund, you can tell from that the funds are frozen under the proceeds of crime, Jersey law. So under the what's colloquially called the money laundering law. And that means that the state has, the Attorney General has alleged that the Abramovich funds are the proceeds of crime, and there's likely to be, or there's a prospect of there being a prosecution. So the criminal law has been used to freeze these assets, and if the justice system moves forward in the way that might be expected, then that would move forward to a prosecution, a trial, and if there was a conviction, to a confiscation order at the end of it. So those assets are at risk of being confiscated, and where they go from there will be the subject of an enormous debate, I'm sure, because again, according to the newspapers, $7 billion has been frozen. So that's what's public. That's what my analysis of what's happening in Jersey, and the receiver's role, the viscount, as I've called him, is to hold the ring. As a matter of Jersey law, all of those assets vest in the viscount. They transfer to him. He becomes the legal owner. And though you can guarantee there'll be a mass of really interesting issues, because it would be very odd if there weren't trusts and companies to be dealt with.
Thank you. And there was the question for James.
Sure. I know we're running late, so very quickly, and actually just to build on the back of what you said, Steve, we had a client, a sovereign client, where a domestic company had been given this very valuable resource, and then when they sold the resource, they moved all the proceeds out to a UK company that was owned by the beneficial owner of the domestic company. So we decided that the insolvency regime in the originating jurisdiction wasn't reliable enough for us to bankrupt that company. But we were able to, with some help from some people who we know here, we're able to prove the flow of funds so we could actually bankrupt the company that was offshore, that was the recipient of those proceeds. So in some ways you can use the, if you get lucky, you can use the insolvency process to sort of forum shop in a place where you have a reliable rule of law. And it usually ends up being where people hide money rather than where they stole it from, just because the places they steal them from might not have the best insolvency regimes. But to answer the question about funding, I have to kind of recall what the question was again, Jean-Pierre. I think it was having to do with structures to deal with political risk, right?
It was about the change of party in power, actually, change of party in power, and how to protect yourself against that. Yeah.
There are two important things that we thank you. There are two important things that we put into our contracts, actually, that guard against that. First of all, usually the choice of law on the contracts is someplace that's a neutral country, so that there is some dispute with the client over fees, that we're not going to to their home turf, I guess, to ask for that. Luckily, we've never really had that happen, but typically our contracts are either UK or US law based. And then we do have special language. I mean, I think regimes understand this too, that there's a lot of risk in making investments in these types of matters. Where we put clauses in our contracts that basically say if there's a change of government, then they would owe us some sort of basically a break fee, just to be able to protect our investment, because those are things that they can't really control. We've been through two re-election cycles with sovereign clients. Luckily, we've been successful in both instances, so we have a little bit more time on the clock. But this is something where our real goal is to be able to recover value for the people of these countries who've been kind of ruined by corruption. But if it gets to the point where we call it the bad actors get back in power, our hope is that at least they would pay us back our principal for us to go away, rather than us publicly air all of the dirty laundry that we found out about them when they were out of power, right? So luckily we've never had to use that tool, but it's an added protection that we're going to need, because you have to have, the client has to be engaged, and if they just are no longer in power, then you've lost your client and a lot of money. So that's the best we can do to protect ourselves against it. That, and frankly, working quickly. I mean, we every time we've been to a few inaugurations before, some of the people on these calls, because we want to get started the day after the person gets sworn in, because we know we're on the clock. If we can do that, that usually gives us enough time to be able to recover value before they, God forbid, get kicked out of power. So.
And just to add to that as well, very quickly, I know we're sort of talking about the insolvency regime, but one thing that's certainly the situation on one matter that I'm working on at the moment is that there has been a change of power, actually, and certainly a shift in power, maybe not a complete regime change. And we've been able to protect the claims that we have by being within an insolvency situation, because it's the liquidator that carries the claim forward. And that obviously protects against any potential regime change.
That's exactly right. Yeah. Also, state-owned enterprises sometimes are sort of these perpetual companies, and so if that's a little bit removed from the politics of a country, sometimes you can still have a client even though there's a change in regime, if they know that they're not having to spend any money and they're just going to be getting back, provided it's not the same people who stole the money, I think if they think it's, you know, found money, let's call it, then you know, hopefully they'll stay engaged, you know, even if there is a you know, turnover in government. But Angela's absolutely right. Once an insolvency practitioner steps in, then it's actually they're a steward of the court who has to oversee the collection of assets, and they become your client. So that kind of structure can survive regime changes, and that's a great tool for us.
So, any other reflection on remarks from any of our panelists? I don't see any more questions actually in the Q&A. So, if not, I guess we have to go to the conclusion. As for my conclusion, first, thank you very much for having invited me to moderate this panel. And second, I think this panel has confirmed, I mean, not only the great competencies of our panelists, but also the nature of what is asset recovery, and including sovereign asset recovery. This is asset recovery is not something, it seems to me, based on my experience and the research that we have done and the cases that we have worked on at the Stolen Asset Recovery Initiative. Asset recovery is not a matter that can be treated with only one type of remedy, definitely. I mean, you need you need to think about a full range of different strategies. Actually, the criminal one, I mean, the criminal law is very useful for prosecutors and investigators. Civil remedies are very important. Insolvency is also a law that needs to be used, but in certain cases. In certain cases, it's going to be very useful. It can be a complement, or it can be an alternative to other tools. But in other cases, it may not be very useful. It depends on the circumstances of the cases. And this is the same also about the type of insolvency proceeding that you are looking for. Like for the question that was asked by our participant, I mean, sometimes probably you will need to use an insolvency proceeding in the country where the fraud has occurred, and then try to obtain an enforcement of some of the measures in other jurisdictions. And in some other cases, you may need to go directly to the offshore jurisdictions where the funds or the assets have been sent or transferred. So it needs a lot of flexibility, and it depends a lot of the circumstances of the cases. That would be my conclusions. Thank you very much.
Thank you.